So, welcome everyone. Hi, hello. Let's begin with our next session called the specialized presentation slot. Firstly, I would like to thank our state sponsor, IP March. Thank you so much for your sponsorship, Stephen, IP March. So, let's begin with the specialized presentation slot, speaker of which is Stephen Yang, the managing patent attorney, IP March. Presentation
Go ahead.
slot is for foreign filing license requirements in China. So, Stephen, you can take it forward from here.
Thank you. Thank you, Ankit. So my topic today is about foreign filing license requirements in China. The reason I brought this up at this conference is because there are more and more R&D centers in China set up by multinational companies. There's a clear trend that R&D activities in China has been far more active than before. And there are legal requirements in China that multinational companies need to pay attention to. First of all, for those that you're not familiar with the Chinese system, China offers three types of patents: invention patent, utility model patent, and design patent. Invention is the regular patent, is valid for 20 years. Utility model is the petty patent, valid for 10 years. Covering only the product claims. I can't patent a method with utility model. And then we have design patent, which is valid 15 years as of June 1st. If you file June 1st, 2021, and afterwards, a design patent is valid for 15 years. If you filed before that, it's 10 years. So the foreign filing license requirement only applies to utility model and inventions. It doesn't apply to developed in China. So many notion that inventions developed in China, you must first file in China, and that is not true. This is not true since 2009 when China changed the law. It doesn't require a first filing in China. But whenever you want to file in a foreign jurisdiction, you must first submit a request for foreign filing license with the CNIPA, which is the patent office in China. It's an acronym for China Intellectual Property Administration. So CNIPA, that's the patent office. You have to file a request for foreign filing license with CNIPA before you can actually file in another jurisdiction. Because in this way, it is not possible to file today in China and tomorrow in a foreign jurisdiction. The patent office want to take a look at what you're filing and give you the approval before they allow you to do that. And the criteria to decide whether you actually need a foreign filing license from CNIPA has nothing to do with the inventor's nationality. It has nothing to do with the inventor's residence. It has to do with where the invention is developed. If an invention is developed at least partially in China, you need to get a foreign filing license from CNIPA. Invention developed in China means the substantive part of the invention is developed in China. So let's say you have a Chinese national who is an inventor, and it develops an invention while he is traveling to the US. So he developed the invention while he is in the US. In this case, a foreign filing license is not needed from CNIPA. It's not needed from China. But if you have a US citizen who travels to China, let's say a foreign company's employee travels to China and visit the facilities in China of the company and makes an invention there, then the foreign filing license requirements from CNIPA is needed. So you have to keep this in mind. Where the invention is developed is the key to decide whether or not you need it foreign filing license from CNIPA. So what if you fail to fulfill the requirement of foreign filing license in China? The penalty is you will not get your Chinese patent. But apart from that, under the framework of patent law, Chinese patent law, there's no other penalties. But of course, if you happen to divulge the national secret, then other laws will apply. But under the framework of Chinese patent law, the only penalty is that you will not get a Chinese patent. But keep in mind that violation of the foreign filing license requirement is a ground for rejection before the patent grant during prosecution. It is also a ground for invalidation in the post-grant procedures. So let's say if there's a whistleblower office before you actually get the patent granted, that you first file in another China, then the examiner can reject your patent application. And the same applies after you get a patent granted. So it is a prescribed ground for invalidating a patent. So this invalidation procedure in China is similar to the IPR procedure in the US or opposition procedure at the EPO. And again, the foreign filing license requirement only applies to invention or utility model. So basically, it applies to the technical solution. If a design is developed in China, there's no need to get a foreign filing license from the Chinese Patent Office. It is also to be noted that for inventions developed in Hong Kong, Macau, and Taiwan, which are part of China according to Chinese law. Okay, I assumed it's okay, so I will just keep going. For inventions developed in Hong Kong, Macau, and Taiwan, foreign filing license are not needed. Is not needed. Keep that in mind. There's a different criteria when it comes to Hong Kong, Macau, and Taiwan. I will get to that later. Now, let's say you decided that you need a foreign filing license. What are the options to get it? So the first option is to file a request for foreign filing license without actually filing an application. And the second is you file a request on the same day as you file the application or after you file a Chinese application. And the third way is to file an international patent application. In that case, the PCT international application. And the PCT international application itself will be deemed as a request for foreign filing license. So what are the documents required when you try to submit a request for foreign filing license? So for option A, if you just want to file a separate request, you must disclose a technical solution to the patent office in Chinese language. Even if you have no intention to file in China, all your technical solutions are written in English, you still have to do it in Chinese language and disclose that to the patent office. And be careful when you do that, because if you disclose a very simple solution, which doesn't really correspond to what you filed in a foreign jurisdiction, then it's always open to debate whether or not you actually fulfill the requirement. So be careful with that. And if you file a Chinese application, it becomes very simple. You just actually, when you file a Chinese application, you just check the box saying I'm requesting this, and the examiners will just examine the specification of the Chinese application. For option C, if you want to file a PCT application, there's no need for a separate request for foreign filing license. The application itself is regarded as a request for foreign filing license, and the PCT application itself can be filed in either English or Chinese language. So how long does it take to get your foreign filing license? The law prescribes a very long period of time. So if you, after a request, the patent office may need up to 4 months to give you a notification. The notification could be okay, we approved foreign fighting license, or it could be we need more time to review. And if you don't receive such a notification within 4 months, it is deemed that you already got a foreign fighting license. But if you do receive such a notification, the patent office have up to 6 months to make a final decision, to inform you about a final decision. And if you don't receive that final decision within 4 months, it is deemed that you already get a foreign fighting license. But in practice, statistically, you get an office action or either approval or notification that they need more time, about 2 weeks. And if you do get a notification that they need more time, usually you will get a decision within another 4 weeks. So it's much faster. And in fact, when you file a Chinese application and you request for foreign fighting license, you get the decision, usually approval, that you can go ahead and file in foreign jurisdiction. At the time, you get the filing receipt, so very fast. And statistically, over 99% of the requests for filing license are granted. And if a PCT application is filed, the timeline is different. The CNIPA, if they think they should not give you the foreign filing license, they will issue a notification decision saying, we're going to terminate the international phase, and they have to do that within 3 months from the filing date. If you don't hear anything within 3 months, you're okay with going ahead and file in other jurisdictions. But keep in mind that filing a PCT application with the International Bureau does not fulfill the foreign filing requirement from China. So do not do that. If you do that, you would have violated the foreign filing license requirement. CNIPA must be the receiving office. So for multinational companies that have inventors in China and in another country, it is important that you fulfill the requirements in all these countries. Sometimes you have to deal with 2 countries, sometimes you deal with 3 or even more countries that have foreign filing license requirement. So you have to meet the requirements in all these countries. The key that to comply with the foreign filing license requirement in China is that as long as you don't file in a foreign jurisdiction before you get a foreign filing license, you are not violating. So the key here is not to file before you get the foreign filing license. Let's say you have a joint invention between inventors in China and inventors in the United States. You can file a request for foreign filing license in the US first, and then without filing an application in the US. So file a separate request. You get the foreign filing license in the US, and then you can file in China or obtain a foreign filing license through one of the 3 ways in China. Okay, so in this way, you fulfill the requirements in both China and the United States. But keep in mind that for each country, it takes some time to get a foreign filing license. It could be a few days here, it could be a few days in other countries, so it is important to allow sufficient time for obtaining the foreign filing license from each and every jurisdiction. Usually, if you have imminent disclosure and you must file an application on urgent basis, the result can be disastrous. So keep in mind, for multinational companies, it's very important that you allow sufficient time for obtaining the foreign filing license. And let's say from the above discussion, some of you may prefer to file a PCT application because it can be done in English. So let's take a closer look at who can file PCT applications with China, with CNIPA. The applicant's eligibility is that Chinese nationals or Chinese residents can file PCT applications in China, and that includes nationals and residents of Hong Kong, Macau, and Taiwan. So that is different from the standard of judging whether you need a foreign filing license. So keep that in mind. And in case of multiple applicants, as long as one of the co-applicants meet the standard, Chinese national or resident, you can file this PCT application with CNIPA. But let's say you're a multinational company, you want this PCT application filed in China in the name of the foreign mother company's name. So in this case, if you have one of the inventors as a Chinese national or resident, you can designate this person to be the applicant only for a remote country, which is very unlikely that you will enter. So there are almost 200 jurisdictions, PCT member contracting states. Designate one that you're definitely not interested, and designate Chinese inventor as the applicant for that country, and designate the foreign mother company for applicants for all other countries. In this way, you fulfill the requirements, meet the eligibility to file PCT application with CNIPA. If you have no one that meets the Chinese standard, you can also designate the Chinese third party only for that remote country. But there's some more details that you need to pay attention to. So in case you want to file a PCT application with CNIPA to meet the requirement for foreign filing license, very likely that you have Chinese inventors employed by the Chinese subsidiary of a foreign company. There's a clause in Chinese patent law says if an employee makes an invention while completing the task given by the employer has a right to apply for and own the patent, which means the Chinese subsidiary should be filing the application and own the application. And this is probably not what you want. You want the application to be filed and owned by the foreign company's name, by the foreign company. So there's a way to do that. There's also another provision in Chinese law says patent commissioning. Sorry, not patent, but commissioning. So let's say if one party retains another party to complete a task, both parties can agree who is the applicant for patent and who owns the patent. If there's no such agreement, the law says the owner and the applicant should be the party who completes the task. But if you agree that is the this Chinese subsidiary and the mother company, foreign mother company, can agree that the foreign mother company is the applicant and owner of the Chinese patent or PCT application and the national phase out of the PCT. If you don't do that, and if you file it in the Chinese subsidiary's name, and later you want to assign this any patent or application to the foreign company, mother company's name, this is regarded as technology export. And there's, it's not the end of the day, but there are additional requirements and additional steps that must be taken. So it is very important to have such agreement in place. So let's go back. So if you have to assign the application from a Chinese entity to a foreign entity, this is regarded as technology export. And there's a catalog of technologies prohibited and restricted from export in China. These I listed the links. There's also a corresponding category for technology import, but you should pay attention to the technology. There was one published in 2009, and during the trade war and technology, let's say, war between US and China, last year, China revised this list catalog on August 28th, 2020. So this is the link for the update. So in the category, there are three types of technologies. One is freely importable or exportable, and then there's a restricted, and there's a prohibited. Prohibited usually is a national defense or nuclear technology. And most of the technology fall in the category of freely importable or exportable. So if you really have to assign from a Chinese party to a foreign party for the freely exportable technologies, you need to go to the local authority of Ministry of Commerce and obtain a registration certificate of freely exportable technology export contract. To just register that contract with this authority, and then you go to CNIPA to register the contract, the assignment, then you're good to go, or the license, you're good to go. But for restricted technology, it is not a registration process at the local authority of Ministry of Commerce. They actually takes time to review the technology. So they give you a technology expert license if they approve that, but that's going to take some time. Once you get this technology expert license, you register it with the CNIPA, and then you're good to go. So that concludes my presentation today. I welcome any questions from the audience. Thank you.
So, hello, Stephen. Thank you so much for such a wonderful presentation on the licensing part in China. So I would request the audience, if they have any questions, so they can come live onto the session by sharing their audio and video, and also they can write down the questions under the chat as well as under the Q&A tab on beside chat. So thank you so much, Stephen, for joining us. And we have a comment from Smriti. Very informative presentation, Stephen.
Thank you, Smriti.
Thank you, Stephen, for joining the IPR Gorilla.
Thank you.